Hiram Walker moved to Michigan from Massachusetts when he was 22. He quickly made his mark as a successful businessman, becoming an influential distiller best known for his Canadian Club whiskey. He was also a dairy farmer, which in this case is the more significant part of our story. Rose, Walker's cow, appeared to him to be unable to conceive and bear young. And because a dairy cow must breed in order to produce milk, Rose's infertility meant that she would not be worth much for Walker. Walker then agreed to sell her to Theodore Sherwood, a banker and fellow farmer. Both parties understand Rose to be barren, and Sherwood intended to slaughter her for beef.
Mr. Walker agreed to sell me Rose the cow, which we presumed to be barren, and in turn negotiated a price based on her weight. After our agreement was settled and I was expecting the cow to be delivered, Mr. Walker refused to sell it. He had found out that Rose was pregnant and wanted to keep her. I filed a replevin action against Mr. Walker, stating that the cow was my property and he could not rescind the contract.
Mr. Sherwood filed replevin action against Mr. Walker, meaning that Mr. Sherwood filed for an action seeking return of personal property wrongfully taken or held by the defendant. In Sherwood's view of the case, the contract had already been settled and the cow was now his personal property that Mr. Walker was wrongfully withholding.
Entering into agreement with Mr. Sherwood, I was under the impression that Rose was barren, and that was the only reason I was willing to sell her. After agreeing on the price and shipment method, a fellow worker alerted me that Rose was pregnant. I refused to sell her after knowing this because our agreement was for the sale of a barren cow. I had no reason or want to sell the cow now that I knew Rose was capable of becoming pregnant.
The agreement letter is as follows. Dear Sir, we confirm the sale to you of the cow Rose, 2nd of Aberlon, lot 56 of our catalog, at 5.5 cents per pound, less 50 pounds shrink. Being enclosed here within, order on Mr. Graham for the cow. You might leave a check with him or mail it to us here as you prefer. Yours truly, Hiram Walker and Sons.
I was expecting to receive Rose on May 21st. However, when I went to collect her, I was informed that Mr. Walker had instructed Rose to not be delivered.
The plaintiff offered Hiram Walker $80 and demanded the cow. Walker refused to take the money or deliver the cow. The plaintiff then instituted this suit.
It appears from the record that both parties supposed this cow was barren and would not breed, and she was sold by the pound for an insignificant sum as compared to her real value as a breeder. She was evidently sold and purchased on the relation of her value for beef unless the plaintiff had learned of her true condition and concealed its knowledge from the defendants. The question arises whether the defendant had the right to refuse to perform the contract. It seems to me in the case made by this record that the mistake or misapprehension of the parties went to the whole substance of the agreement. If the cow was a breeder, she was worth at least $750. If barren, she was worth not over $80. The parties would not have made the contract of sale except upon the understanding and belief that she was incapable of breeding, and no use as a cow. It is true she is now the identical animal that they thought her to be when the contract was made. There is no mistake to the identity of the creature, yet the mistake was not of the mere quality of the animal, but went against the very nature of the thing. A barren cow is substantially a different creature than a breeding one. There's as much difference between them for all purposes of use there is between an ox and a cow that is capable of breeding and giving milk. If their mutual mistake has simply been related to the fact whether she was with calf or not for one season, then it might have been a good sale. But the mistake affected the character of the animal for all time in its present and ultimate use. She was not in fact the animal or kind of animal the defendants intended to sell or the plaintiff to buy. The court should have instructed the jury that they found that the cow was sold or contracted to be sold upon the understanding that both parties that she was barren and useless for the purpose of breeding, and that in fact she was not barren but capable of breeding. Then the defendants had the right to rescind and refuse to deliver, and the verdict should be given in their favor. The judgment of the court below must be reversed and a new trial granted with the cost of the court to the defendants.
There is no question but that the defendants sold the cow representing her of the breed and quality they believed the cow to be, and that the purchaser so understood it, and the buyer-purchaser believing to be of the breed represented by the sellers and possessing all the quantities stated and more. He believed she would breed. There is no pretense that the plaintiff bought the cow for beef, and there is nothing in the record indicating that he would have bought her at all, only that he thought she might be made to breed. Under the foregoing facts, it is held that because it turned out that the plaintiff was more correct in his judgment as to one quality of the cow than the defendants, and a quality two which could not by any possibility be positively known at the time by either party to exist, the contract may be annulled by the defenders at their pleasure. In this case, neither party knew the actual quality and condition of this cow at the time of sale. The defendants thought the cow could not be made to breed, but the plaintiff says that he thought she could be made to breed, but believes she was not with a calf. The defendants sold the cow for what they believed her to be, and the plaintiff bought her as he believed she was after the statements made by the defendants. No conditions were attached to the terms of sale by either party. It is not the duty of the courts to destroy contracts when called upon to enforce them after they have been legally made. There was no difference between the parties, nor misapprehension as to the substance of the thing bargained for, which was a cow supposed to be barren by one party and believed not to be by the other. As to the quality of the animal, subsequently developed, both parties were equally ignorant, and as to this, each party took his chances. In this case, the cow was sold, the one delivered. What might or might not happen to her after the sale formed no element in the contract. The judgment should be affirmed.
As such, the ruling of the court was that the original judgment was reversed and the new trial granted on the grounds that the defendant had the right to rescind the contract because there was a mutual mistake as to the substance of that contract.
We all might be wondering what the significance of Sherwood versus Walker is, or should I say what has commonly become known as the pregnant cow case. To understand this specifically, we need to remember that this case ultimately deals with the issue of an agreement between two parties regarding a particular subject and the nature of that particular subject changing. As you can probably tell by now, the subject in this case was roast the cow. As the court ultimately ruled that Hiram Walker had a right to rescind the contract and thus keep Rose, this case has since become an important case in American contract law regarding the doctrine of mutual mistake, which holds that a contract is voidable if both parties share a misunderstanding regarding a significant fact in the agreement.